My sincere thanks to the organizers at Play for presenting me with this opportunity to talk about consumer law. First and foremost, let me make one thing clear right off the bat. Everything which began under the old act will continue under the old act. If you have filed your case under the 1986 consumer law, that law will apply for your case. And if you have not yet filed your case, you can file it under the new act. There was a Consumer Protection Act in 1986. There sought to be deliberations to update the so-called outdated law, and eventually, after failed attempts in 2015 and 2018, finally the Consumer Protection Act 2019 was passed, which updated and replaced the old 1986 Act. Now, who is a consumer? When the Act says that the Act applies to all goods and services in the country, it means that you can be a consumer of goods or you can be a consumer of any service. So now who exactly is a consumer? You see, this section 2(7) of the Act defines a consumer, but in short, if you have paid money to consume, you are a consumer subject to some exceptions, which I will come to. You can consume goods, for example, food, or you can consume services. For example, you get a haircut. Let me ask you one question. Suppose you have called for some electronics from Amazon. So the question is, has Amazon provided you with goods, or has Amazon provided you with a service, or has Amazon provided you with both goods as well as a service? You see, friends, Amazon has given you goods as well as a service. Suppose you have undergone some important medical treatments. You are a consumer, and everyone from the small clinic to the big hospital, they come under the Consumer Protection Act. In metropolitan areas like Mumbai, whose property prices are one of the highest in the world, a small flat of even 400 square feet can sometimes cost crores of rupees, if not lakhs. And the builders who construct these flats, they come under the Consumer Protection Act. So now you must be thinking, everything I do, I am a consumer. But like I said, there are some important exclusions. There are some important scenarios when you are not a consumer. And I will show you. So these on screen are the scenarios when you cannot take help of the consumer protection law. If you are a consumer for free, for example, many times there are free medical clinics which are organized by the government or by the community, or sometimes you get free advice from a doctor. If you have paid 0 rupees, you cannot come under the Consumer Protection Act. But if you have paid even 1 rupee, yes, you are a consumer. Next, one important concept here is commercial purpose. Commercial purpose is basically if you take any goods or service for profit. If your objective is profit, you are not a consumer. However, the peculiar part is that certain kinds of commercial purposes are allowed. If you can show that you are doing self-employment, and if you can show that this self-employment is for your livelihood, you can do commercial purpose and you can still take help of the Consumer Protection Act. Let me give you examples. You have a general store. The general store is your livelihood and you yourself work there every day. So if you take a fire insurance policy for the goods under these conditions, you are allowed to come under the Consumer Protection Act. Why? Because there is self-employment and there is livelihood. By comparison, you suppose you own several such chains of stores and you don't work in any of them, you have managers. Question can and will be raised if you are a consumer, whether there is self-employment. Let me give you another example. Many times people invest in properties for profit. In some cases, they purchase the flat under construction and they sell it when the prices are profitable. This is called resale flat. And sometimes they give the properties on rent for profit. These are purely and squarely a commercial purpose, and a consumer case will be lost against the builder if the builder can prove that your flat is for resale or your flat is for rent profit. So this is what we mean by commercial purpose. Commercial purpose in short for profit. And if you can show self-employment and if you can show livelihood, it is okay if you do commercial purpose. Now the least invoked and least important one of these exclusions is something called personal service. You cannot file a consumer case against your servant or butler, but the underlying principle is important. Consumer law applies only to contractor and customer relationship and not to master servant relationship. So friends, if any of these conditions are there, you cannot take help of the Consumer Protection Act. Now let me ask you one more question. Suppose the builder has not given you possession of your flat on time. Where will the case lie? Will the case lie only in RERA? Will the case lie only in consumer? Will the case lie in both the courts at the same time? Or will the case lie in only one of the courts? I will tell you the answer in a little bit. One spirit of this consumer law is that it is something called as an additional remedy. You see, consumer law is an extra option which the law gives to the consumers to protect their rights. You see, many of your disputes already have designated courts. For example, if your dispute is regarding your electricity bill, there is the Electricity Commission and the Tribunal under the Electricity Act. If you purchase a flat from a builder, there is the RERA authority and the tribunal under the RERA Act, and other cases generally lie in a civil code. Now, what this consumer law says, it says that the consumer law remedies are in addition to other laws. What this means is that if I have a dispute with the builder, I can choose. I can choose whether I want to file a case under RERA or whether I want to file a case under consumer. The courts have held that the consumer law remedies are parallel, they are concurrent and not exclusive. So the litigant has to choose whether he wants to file a case under RERA or whether he wants to file a case under consumer. But you cannot ask for the same relief in both the courts. For example, I can get refund only from one court. I cannot get one refund from RERA and another refund from consumer. I cannot get I cannot file a double case for the same remedy that I want. So the litigant and the lawyer, they have to sit down and they have to analyze the client's needs. They have to ascertain and determine which law will be beneficial for the client to file a case under. With this background, let me tell you what are the legal offenses consumers can face. So whatever type of grievance that you face, suppose your parcel is late or some wrong order is delivered, suppose the insurance claim is wrongly rejected, suppose the flat possession date is delayed, whatever your specific type of grievance, these on screen are the categories under which they come under the Consumer Protection Act. The consumer law will look at your grievance through these following categories. Where in the following does your grievance fit exactly? There is deficiency in service. There is restrictive or unfair trade practice. Sometimes the goods are defective or are duplicate goods. Sometimes the contract is an unfair contract. Suppose you have suffered some harm or injury from the product. Sometimes the advertisement can be misleading. Whatever type of wrongdoing is done to you, these are the types of cases that you can file under the consumer law. And believe me, friends, all these definitions, they are very wide, very liberal, very inclusive, and very, very consumer friendly. In fact, the new Consumer Protection Act is so well thought of that if any new type of wrongdoing takes place, the act will not need to be amended. So how exactly are these rights protected? Let me tell you. The consumer law has two main types of bodies which will safeguard your rights. One is called the CCPA, the Central Consumer Protection Authority, and the other is the establishment of consumer courts, which is entirely different from the CCPA. Let us talk about the CCPA. The CCPA will protect rights of consumers as a class. For example, in 2015, there was a Maggi noodles case in the Bombay High Court. The Food Safety Administration ordered a recall of all the Maggi packets because of suspected high levels of lead and MSG. If today the poison foods case comes out, the food authority can take action, and now this consumer authority can take action. They can take action to protect the rights of consumers as a class, the class of people who are eating the poison food. Let me give you another example. There was the Volkswagen diesel emission scandal. The car company Volkswagen illegally and unethically manipulated the pollution reading of its cars. It said that your cars are less polluting, whereas actually they were very much more polluting. If today something like that takes place, the CCPA can protect the class of car purchasers. Now, in order to protect these class of consumers, the CCPA has been given the power of a regulator. You see, when the coronavirus pandemic came out, suddenly advertisements started that this and that you do and it will cure coronavirus. You take this medical supplement, your health will get better. Our sanitizer kills 99% germs, including coronavirus. The CCPA authority, being a regulator, it came out with strict warnings. If you do not have adequate research and you do not have adequate science, we will penalize you if you make such unsubstantiated claims. The primary function of the CCPA is to look into the wrongdoings. But in a very positive approach, the authority has also been given very positive functions to spread awareness, to encourage NGOs to work with the consumer protection agencies, to suggest welfare measures to the central and state governments, and most importantly, the CCPA can file cases in consumer courts on behalf of the consumers everywhere. So this authority can look into wrongdoings, this authority can fix loopholes in the law, this authority can take positive precautionary steps to prevent the wrongdoing. So how exactly does it do all of this? The CCPA sits at NCR region in Delhi and it can have regional offices wherever it wants in India. This authority consists of a chief commissioner who is the boss and other commissioners who are subordinate to the chief commissioner. This authority also has an investigation wing. This investigation wing will be headed by a director general, and there can be other directors who are subordinate to the director general. The duty of the investigation wing is to conduct an investigation as directed by the CCPA. So you see, the investigation wing is answerable to the authority, and the CCPA authority is answerable to the central government, the consumer ministry. The CCPA is authorized to receive complaints even electronically and even without anyone complaining. If the CCPA itself suspects that there is any kind of wrongdoing going on, it can, on its own suspicion, suo moto, it can take action and it can begin investigation into the wrongdoings. The investigation is done by the investigation wing. This investigation wing will submit a report to the CCPA authority. It will submit a report of the investigation. Now, for doing this investigation, these officers have very, very strong powers. For example, these authorities can engage experts and professionals for any kind of scientific, biological, chemical, physical, even psychological gimmicks which might be being played. Then these authorities can call upon the lawbreaker to produce anything within their possession, any document, any record, any book, any register, any article, any item under the sun. This authority and the wing can tell any person that you produce this for me because I am doing investigation. For doing this investigation and for doing this search and seizure, they have these search and seizure powers. They have powers so that they do not need to approach the police separately. When they seize the goods can even be sent to the appropriate laboratory for testing. For example, is the Maggie actually poisonous? Is the Volkswagen car under-reporting its pollution? Even whether any kind of digital forensics is required on any mobile or computer. So this power of search and seizure is very strong and very dangerous. Now, if you are a business owner, let me tell you one safeguard and precaution is given to you. If the government authorities, if they do something called a vexatious search, if they do a vexatious search, means if they trouble you with investigation, even though there is no reasonable ground against you, you as a business owner can take action against the government. If the government has done vexatious search upon you, you can sue the police officers. They can get imprisonment up to 1 year or fine up to rupees 10,000 or both. After investigation, this CCPA authority, it can invoke either section 20 orders or section 21 orders if it finds that there is any kind of wrongdoing. Section 20 orders are for two types of things: violation of consumer rights and unfair trade practice. And section 21 orders are for false or misleading advertisements. Now you must note that these section 20 and 21 orders are not at all weak and not at all toothless. Let us look at what kind of orders can be passed by the CCPA to stop the wrongdoing. You see, these section 20 orders, they say that the CCPA authority can pass such order as may be necessary, which means that anything and everything required to stop the wrongdoing can be ordered by the CCPA. So one should not underestimate the wide range of power under this section 20 order. In fact, the CCPA has already invoked this several times now, especially during the coronavirus. Also under this section 20 order, express power is given to the CCPA to order a mass recall and mass reimbursement, which it can invoke over the whole country. CCPA now has the power to tell food companies or to tell Volkswagen to do a mass recall and to do a mass reimbursement to all the consumers who have suffered. Now coming to section 21 orders. Section 21 orders are very big and dangerous provisions are there in case of false or misleading advertisements. Section 21 orders provide for 4 types of punishments or penalties, which it has given from subsections 1 to subsection 4 of section 21. The difference between these 4 types of orders is not only the type of penalty, but also whom the penalty shall apply to. On screen, you will see there is an analysis and a comparison of the section 21 orders. But in short, CCPA can levy heavy fines that can go up to rupees 50 lakh, and the CCPA can say you stop doing this advertisement for a maximum of 3 years. And these fines can be levied on the trader, manufacturer, endorser, like celebrities, they will come under endorser. They can levy it upon advertiser, publisher, and last but not the least, 21(4) even applies to any person. So anyone doing false or misleading advertisement, the residuary provision of 21(4), it covers any person if he is trying to circumvent and manipulate the law. Now, for passing section 21 orders, the CCPA has to take into account certain considerations. The CCPA has to take into account certain factors to to pass Section 21 orders, it has to consider what is the size of the population that is affected by the advertisement. Was that advertisement run in a local area, or was it run pan-India? What is the size of the population? What was their vulnerability? Whether they were illiterate and uneducated, whether they are under some kind of compulsion like a monopoly. CCPA has to consider what is the frequency and duration of the advertisement. That advertisement was running for one whole year during coronavirus, and the CCPA has to consider what is the gross revenue earned by the advertisement. So the bigger the wrongdoing, the bigger the penalty. To defend Section 20 and 21 orders, the business has many safeguards and precautions. When the CCPA wants to levy some kind of penalty under Section 20 or 21, the business must be given an opportunity to be heard, and orders cannot be passed by the authority without hearing the other side. So a fair trial is guaranteed. The persons upon whom the penalties are levied, they can take certain defenses. For example, the business can say that precautions were taken to ensure the correctness of the advertisement, or they can say, or they can take a defense that the order of the CCPA was not delivered to him. So the consumer law sets a very fair stage for even the business owners, whether they are manufacturers, advertisers, distributors, whoever, they have a right to be heard and they have a right to defend themselves against this order. So the business has to either comply with the orders or they have to challenge the orders in an appeal. So whoever is not satisfied with these 20 and 21 orders, he can challenge them by filing an appeal in the National Consumer Court within 30 days from the date of the order. But if you don't appeal and if you do not comply, the CCPA will send the matter for execution, and the magistrate can levy one more punishment on top of the existing penalty. This magistrate punishment can go up to 5 years imprisonment and fine up to rupees 50 lakh. So now you can imagine how dangerous it is to do a misleading advertisement. You should feel very confident against all the wrong claims which are being given to you. Now let me come to the masala of the CCPA. You must be wondering, so much power is given to the CCPA, but what has it done till now? Can you read, please? So you see, the consumer ministry suspected that some of the e-commerce entities, they were posting fake reviews on their own websites. Investigation has now been started. Now we will see what the CCPA is doing against non-compliance of e-commerce rules. Can you read, please? So when you go to Amazon or Flipkart, around the time when you are browsing the products or when you are doing add to cart, you as a consumer, the e-commerce rules guarantee you various details. What is the country of origin? What is the actual price? There are various disclosures in the e-commerce rules. Now, the CCPA authority has taken cognizance and it is investigating the matter that why you are not displaying what you are supposed to display. Now, CCPA has issued an advisory that do not take advantage of the pandemic. Can you read, please? So when the pandemic started, coronavirus was a new virus. Existing research did not exist. When businesses sought to take advantage of the situation and of the consumers, or rather when it sought to take disadvantage, the CCPA issued advisories that do not make claims if you do not have the science. Now we will see how some honey brands are in trouble. In short, you see, pure honey is naturally good against coronavirus because of its nature. But brands sell sugar syrup, marketing it as honey, And that also as our honey is good against coronavirus. Can you read, please? So in this case, the food regulator and the consumer regulator have joined hands. They have offered each other cooperation and investigation is underway. So in short, false and misleading advertisement might be happening. But in this honey case, for example, what happens if any of the ingredients is an adulterant or a spurious goods? So these adulterants and spurious goods is not only if there is an ingredient, that I am saying only as an example. If any good is an adulterant or a spurious goods, then there are penalties prescribed. For adulterants and spurious means counterfeit or duplicate goods. For adulterants and spurious goods, the penalty which is prescribed is corresponding to the harm or injury that the consumer has suffered. So the slabs and categories are where there is zero hurt, next where there is simple hurt, next where there is grievous hurt, and lastly where there is death. So we saw in the earlier slide that sugar syrup can actually be bad for you. If any ingredient, for example, is found to be adulterant or spurious, and if the CCPA investigation reveals the link to death, the punishment is both jail as well as fine. Jail up to 7 years and fine up to 10 lakh rupees. Now, before we go to the provisions of the consumer court, let me quickly tell you how the district collector is roped in to he is roped in the consumer law to resolve the disputes. The district collector shares many powers with the CCPA. Just like the CCPA, collector can receive complaints even electronically. Collector can do investigation within his jurisdiction, and even the collector has to send a report of the jurisdiction to the CCPA. Even CCPA can tell collector that you do investigation within your jurisdiction, and just like the CCPA, the collector can tell anyone, you produce this document to me, I want to do investigation upon you, and the power of search and seizure is given. Now coming to consumer courts. First, let me tell you about these websites. There is Confonet and there is eDakhil. When you file any case in a consumer court, the consumer court will upload it to Confonet. And when your case goes on from hearing to hearing, its updates and details are updated on Confonet. On Confonet, you can see the case status. You can see what are the previous dates in your matter. You can see what is the next date. You can see what are the orders passed in your case. And in fact, we can even find judgments of other cases from Confonet. Many times, newspaper, it is journalism and fourth estate. In newspapers, consumer court cases are reported and using certain parameters. For example, date of judgment. Newspaper article will say consumer court on Tuesday passed an order. So parameters like date of judgment, what are the names of the parties, etc. We can obtain judgments from the Confonet website. Whatever is reported in the newspaper, you can find it in the Confonet website. It is a public domain and anyone can see anyone's case status. Anyone can see anyone's case status if they have the relevant parameters. Now, the next website is eDakhil. eDakhil stands for e-filing, online filing. Of late, because of the coronavirus, most of the courts have shifted online and the consumer courts are no exception. Now, in 17 states in India, you can file your consumer court case online on eDakhil. You can file all aspects of the case. You can file the court case, you can file an appeal, revision, reply, everything you can file on eDakhil. I will show you how to operate these websites. And in fact, the eDakhil website, the government has made it so user-friendly. They have made guides in PDF. They have made guides in video tutorials, how to use the website. And these guides and videos are in English as well as Hindi. We will see later. Now, let me share with you some of the industries which face the consumer litigation. So there is airline, banking, there is the goods industry, electricity, finance, housing, insurance, medical, postal, railways, service industry, telecom, transport, and tourism. When it comes to the consumer codes, there are three levels of the consumer codes. They can have the district, state, and national. The pecuniary jurisdiction, which means that your monetary jurisdiction, your case is for how much money the corresponding court it will go to. The pecuniary jurisdiction will be calculated and determined only as per the money that you have paid. So for example, if my flat costs 5 crore rupees total, but I have only paid the first installment of 20 lakhs and I want to file a consumer court case, then I will have to go to the district consumer court and not the state commission, because I have paid only 20 lakhs, and that is why district consumer court becomes the jurisdiction. So this is how pecuniary jurisdiction is determined, by the value that is paid. Now let me share with you some case studies which have taken place. First one, the airline, it lost the luggage of the consumer. When the consumer took it up with the airline offered 350 rupees per kg. So the maximum he would have gotten would be somewhere between 7 to 10,000 rupees. The consumer said, my dear airline, I have done some shopping and I have 75,000 rupees worth of shopping in that bag. But the airline refused to pay him 75,000 when the luggage was lost. The consumer went to the consumer court. He showed receipts of each and everything in the luggage. The court granted him the 75,000 and the court granted him 10,000 rupees extra as compensation. Second one, the airline was told to pay 48,000 for not allowing the passenger to transfer the excess check-in baggage to the cabin. The hand baggage was not allowed to be transferred to the cabin and he got compensation. Third, खाने में कपड़े का बटन मिला है यार. Airline has been told to pay 55,000 rupees. A button was found in the airline food. In the same flight, a sitting member of parliament was traveling. He saw all this, and to extend his cooperation, he gave an affidavit in the consumer court case. So my dear friends, you may appreciate that the consumer spirit is so wholesome, friendly, and consumer centric that the consumer will get the relief. Next, in this airline, the consumer had taken a return trip. When he went to board, he was only 5 minutes late for boarding, but still the boarding counter was and even the boarding counter was open. There was no rush, there was no hand baggage. Still, he was not allowed to board, even though he was only 5 minutes late. So the airline did not allow him to sit on that flight. So he had to book another flight. Both his flights were round trips. The first one where he was not allowed to enter, that was also a round trip. He was not allowed to enter, so he booked another flight which was a round trip. So when the time came for him to take his returning flight, the airlines did not refund him his pehle wala round trip. When the consumer court saw these facts, the consumer court said nothing doing, the airline is at fault, and the court granted 1.5 lakh rupees refund and compensation. Next, the consumer had planned a trip and the trip would make him eligible for reaching a certain number of points, after which he could claim the benefit of some reward. When planning his trip, the consumer had emailed the airline in advance about his calculation. He had messaged the airline 40 days in advance that, see, this is my calculation. When I take this trip, I will get so many points. And when I do this trip and get the points, I am supposed to get the reward. He messaged in advance. Airline did not confirm and airline did not grant him that. Airline did not grant him the extra points, did not grant him the reward. 1.5 lakh rupees refund and compensation was given. Let us look at banks. A person went to an ATM and ATM did not dispense the cash. His account was in one account, ATM was of another, his account was of one bank and ATM was of another bank. CCTV footage was also not given and both the banks took contradictory stands in the consumer courts. So the consumer court penalized both banks. The consumer court said he is the consumer and you are supposed to give him relief. The consumer court said whoever is responsible from the two banks, you fight it out in the appropriate court. This is the consumer court. Consumer has suffered and consumer has to get his remedy. So both the banks were made liable to the consumer. Next, jewelry went missing from the locker. So 1.5 lakhs rupees compensation was given to the consumer. Next, the bank was not returning the original documents because bank was holding it hostage for some or the other service. 15,000 compensation was levied upon the bank. Next, RBI circulars, they tell the bank to take consent from the consumer under various scenarios. You take consumer before starting some facility, you take consent of the consumer before issuing credit card, before issuing loans. The bank had not complied with this consent circular of the RBI. 65,000 rupees compensation was granted. In one interesting case, forged checks were issued, and when the consumer took it up with the bank, when the consumer noticed that amount has been deducted and the consumer had not issued the check, when consumer took it up with the bank, bank did not solve it. Consumer court relied upon handwriting analysis. Handwriting expert was called and the bank was penalized rupees 50 lakhs for not investigating the consumer's grievances. In one interesting case, the bank executed an overdraft for a fraudster. So someone was doing some kind of fraud on the account holder, and the account holder had to not even started the overdraft facility. Bank was penalized that how you can allow overdraft when the service has not been activated. In one case, the bank had used the customer's fixed deposit as a lien for a stranger. Lien means security. So the customer's fixed deposit became a security for a stranger. The consumer said, I don't know who this stranger is. How can you jeopardize my fixed deposit? The bank was penalized by the consumer court. Now, in one case, the consumer, he had left his goods at the bank for security. He had taken some loan from the bank, and as a security, he had hypothecated some goods. And in doing this, an agreement was entered into, and the bank said, we will renew your insurance from time to time, insurance for the goods. So this went on for several years, and several times the bank renewed. Eventually, the consumer, he reimbursed whatever was the amount he had to pay the bank, and he took back the goods. But the bank had forgotten to renew the insurance. So the goods which were uninsured, they got stolen from the consumer, and the bank was made responsible for not renewing the insurance. So this is a type of a consumer case where the bank did not renew the insurance for the goods when you have availed of some loan facility. This is squarely a consumer case. And in one bizarre case, the locker owner was shown as deceased, dead in the bank's records. Bank says he is dead in our records. Let us see examples of defective goods. A car was purchased, but there were many problems. The consumer court, in the favorable order, it told the consumer, it told the service provider, you replace the car and give a new car. So the car seller was aggrieved by the order and he went in appeal. He lost in appeal, and now the consumer said, I do not have faith in you. I do not want car from you. You give me the refund. So the consumer court granted the relief. Consumer court accepted the requirement of the consumer. Consumer court granted the refund, and it doubled the compensation from 12,500 to 25,000. Next, when fridge was replaced 4 times, but none of the fridges worked, the consumer court called an engineer and told him to give a survey report, and accordingly the consumer got relief. So the consumer courts even have powers to order, in law we call them commissions. Consumer court can engage experts, consumer court can handwriting experts, such industry expert, technical expert, whatever it wants, the consumer court can appoint consumer court can engage so as to come to the final determination whether there is a fault or not. In one case, a bed was sold saying that it has medical benefits for polio and paralysis. But when it was found that this bed made no difference to a patient who was actually a polio paralytic, the court penalized. 600 grams of detergent was being marketed as 1 kg. The court said you deposit 1 lakh in the government treasury as penalty. So this was a false advertisement that it was doing, that 600 grams was actually being marketed as 1 kg. Now, one more case is interesting because of the principles. There is a water purifier company, and in another party is the agent, the authorized seller. The agent, the authorized seller, he sold with tall claims that this is a very long-term product. You put this product for many, many years, you will not have to change it. So the agent made such a representation and sold the product to the consumer. In the court, the water purifier company, it tried to take the defense saying that, no, those claims were made by the agent. Court said nothing doing. We cannot rely on the instruction manual. When your authorized salesperson has said that it will last for so and so, the company's claim of refer to the service manual, it cannot be relied upon. If someone has made a representation on your behalf, then the principal is bound by the claims of the agent. In one case, Amazon had sold gold coins without the BIS mark, Bureau of Indian Standards mark. It was penalized 2.9 lakhs. The consumer court, on the one hand, one important aspect of this case, the consumer court said, you, Amazon, are liable for all the formalities to procure this product. You cannot just say that it is a gold coin and I have delivered only the gold coin. If there are certifications, you are supposed to deliver. If there are any compulsory statutory compliances, for example, there are prescription medicines which cannot be sold to you without a prescription. So if there is any medicine delivery app, it delivers to you medicines, it delivers to you prescription medicines without the prescriptions, that will not be allowed. Whatever is required to sell the goods, the business, including the e-commerce, they are supposed to procure it and then only sell it to you. Now, another reason why this case, Amazon case, is important, the court has levied a higher penalty saying that you have done deficiency in service also, you have done unfair trade practice also. Two types of offenses, that's why heavier penalty is levied. In another case, Flipkart sold a phone, but Flipkart did not mention the IMEI number on the bill. So when the consumer went to the service center, he was denied service and repairs because the service center said that your invoice does not have your IMEI number. Consumer court held Flipkart responsible. Now, we have seen cases where experts are relied, where technical people are relied. Now, this one case, the consumer court has called the insurance chairman to the court. Can you imagine? The IRDA body chairman was summoned to the consumer court to be made answerable. What had happened in short in this case was, the consumer said, I bought insurance 2 years ago, but till date I have not got my policy papers. Government summoned the insurance chairman. The basic principle of insurance in consumer law is that do not reject a genuine claim. Insurance companies are very keen to stick you to some or the other ground of rejection or exclusion. So the courts say, do not reject a genuine claim. Now let me share one interesting thing about MRP. Did you know that if you go even in the most expensive 5-star hotel, MRP items have to be sold at MRP. They can charge you more than MRP only if they are opening it and serving it to you. There have been many instances of hotels, restaurants, cinemas, and shops being charged up to rupees 30 to 40,000 for charging more than MRP. You have to display the MRP and you have to charge at MRP. A Hyderabad consumer court granted 65,000 rupees compensation against KFC. Why? Because KFC added 33 rupees as packing charges on Swiggy and adding GST on that. Can you imagine 65,000 compensation for 33 rupees plus GST packing charges? In another interesting case, Colgate 50 grams pack was rupees 20, but 150 grams pack was rupees 92. So for 3x the size, the price was more than 4x. The company tried to say that this is our product and it is our wish, but the consumer court said no and levied 65,000 rupees penalty. So can you imagine that the company has said that it is our product, it is our choice. Still consumer court said no, nothing doing, and penalty was levied. Now in one case, the 5.5 lakh rupees compensation was given to a car owner when the service center towed the car but did not inspect it and did not repair it on time. Now, coming to the important field of medical cases. In medical consumer law, there is one prevailing principle. If the doctors have followed ordinary care and protocol, they cannot be made liable for something extraordinary. Recently, the court has acquitted. That means it has not put any liability on two doctors. What was the reasoning is important. The court said you are not responsible, and it said that in the realm of diagnosis and treatment, there would be ample scope of genuine difference of opinion, and a doctor would not be termed negligent merely because his conclusion differs from that of other professional men. So this reason was given for acquittal. In medical consumer cases, the court will examine the symptoms and the court will determine what is the ordinary case of ordinary care and protocol in that scenario. But courts are judges, courts are not doctors. Who decides this expert question that what is the ordinary care and protocol? That so and so has taken place, so and so reaction of blisters or rashes came on the skin. Judges are not doctors. Who decides what is the ordinary care and protocol? In these cases, consumer courts will rely on an expert doctor's opinion and expertise. Or if not one doctor, a government hospital, a committee of doctors in a government hospital, the matter will be referred to them or they will be called to the consumer court that so and so has happened. Did the doctor follow ordinary care and protocol in treating? Believe me, friends, to establish ordinary care and protocol, even medical literature and medical textbooks are read out aloud in the consumer courts by the lawyers to establish what is the ordinary care and protocol in the cases. And then the court will see, number one, was there any negligence? And number two, did the doctor do the procedure only for profit, which is called informed consent? There are so many cases that some surgery is done when absolutely no surgery was required because the issue was something else altogether. Purely medicine and injections would have solved the problem, but the doctor did not follow the protocol. Doctor wanted to opt for surgery for getting money. So this is what the consumer courts will look at in medical cases. Typically, medical cases revolve around carelessness around surgeries. Before surgery, for example, doctors have goofed up with anesthesia. During surgery, something has gone wrong. For example, doctors have operated on the wrong organs and doctors have left medical equipments, including scissors, inside the patient, and post-operative carelessness can be there. For example, doctor has not observed the patient seriously for complications. So in medical cases, pre-operative, during operation and post-operative carelessness are the highlights. You see, housing in consumer law is a very big field. In housing, clients face many types of issues. Possession is delayed, area is smaller, title and permissions are not clear. Many things can go wrong. I have put on the screen what type of cases go on in the housing field in medical, in the housing field and consumer. When we think about housing and consumer law, what immediately comes to mind is that I have bought a house from a builder and I have issues with the house. But friends, did you know that you are a consumer even against your housing society? Many times societies create nuisances. They do not approve your applications on time. They do not issue you NOCs on time. They inflate your maintenance bill. They do not do the compulsory meetings on time. They do not give you audits and accounts. They do not do elections. They sometimes frame illegal laws and illegal fines and penalties. You can take even your housing society to the consumer court. It is well settled. You are a consumer even in respect of your housing society. Your managing committee is giving you service for the time that you are staying there. The reliefs which we opt for in the consumer court in the housing cases, the relief depends on the client's requirements. Does the client want a refund or does the client want possession? In cases of refund, there the courts have granted interest and the builder has to pay interest from the date of payment till the date of compliance. So till the date of compliance means till the date that actually the money is paid by the builder. For example, today you get an order saying do refund, but builder ends up paying it to you 6 months later or 1 year later. You will get the interest for these 6 months or 1 year which the builder has delayed. Compensation is also very heavy under housing disputes. And in other cases, when your client wants possession of the flat, there are orders to make the builder pay the heavy burden of stamp duty and for reliefs like fix the title of the property. Do not sell me a house with a defective title. In the housing cases, especially, the consumer courts pass time bound orders. We have got so many orders from the consumer courts telling the builder do so and so within a 30-day time limit, within a 60-day time limit, within a 4-month time limit. Consumer courts can come down very heavily. Now, it is worth noting, dear friends, that this Consumer Act, the new Consumer Act, has a new concept called unfair contract. One of the biggest things plaguing the consumers everywhere, especially in the real estate industry, are unfair contracts. The term unfair contract is defined as a contract having terms which cause significant change in the rights of the consumer. And it is a very inclusive definition. So if tomorrow there is a new type of unfair contract, inclusive definition means yes, this also is a type of unfair contract. This also is a type of unfair contract. It is included in the definition. It is a very inclusive definition. Some examples which this provision gives: unreasonable money or obligations, if it is imposed upon you, it is an unfair contract. For example, if you do not reply within 2 days, your money will be forfeited. Such a stipulation is an unfair contract. Unilateral termination upon you is an unfair contract. For example, if you do not reply within 2 days, this contract shall deem to be terminated. This is an unfair contract. Many times, especially in the housing agreements, when you purchase an agreement for your flat, there is a disproportionate penalty for breach. This becomes an unfair contract. For example, the builder says, if I breach, I will pay 9% interest as penalty, but if you breach any of the payments, you will pay 24% interest as penalty. So disproportionate penalty, uneven penalty for a breach of the contract is an unfair contract. It is a very inclusive definition. It is only the terms which is unfair, which is null and void. So it is not the whole contract which is set aside. It is not the whole contract which is null and void, only the unfair stipulation. Now quickly let us look at how consumer court cases happen. Under consumer courts, only the consumers can file a case. So it is a one-way street. The business cannot file a case under the consumer court. If the business has a grievance, if the business has a grievance against the consumer, it will have to go to the civil courts. Businesses can only defend and businesses can only appeal in the consumer courts. You must file your complaint within 2 years from the date on which your grievance arose. And beyond that, you have to show reason why it took longer than 2 years. In consumer courts, it is not compulsory to have a lawyer fighting for you. You can fight as a party in person also. But many times it comes upon the question of whether it is advisable to fight as a party in person. When the stakes are less, for example, your phone is worth 10-20,000 rupees. In such a scenario, it is feasible neither for the consumer nor for the lawyer to charge fees in such a matter. So in such cases where stakes are small, feel free to argue party in person. But many times your stakes are large and the consumer court is still a court. It has many technicalities. So for example, if your matter is in state commission, state consumer court, it means that you have actually paid 1 crore rupees or more. In such a case, nobody will argue on their own. Nobody will try to save cost on a lawyer if they have paid. When stakes are high, for example, if your matter is in the state commission, nobody will risk fighting the case on their own because the consumer court is still a court and there are many technicalities. Now this new act, this new Consumer Protection Act, it introduces a groundbreaking provision. Regardless of where your wrongdoing took place, you can file a consumer court case in your residence or office area jurisdiction, and the opposite party will have to travel to wherever you have filed the case. This is especially important in the travel industry. Suppose you file your case, but the admission hearing is taking long for whatever reason. Admission hearing is basically consumer has a one-on-one with the judge. He has to convince the judge that this is actually a type of consumer complaint. The case comes within the consumer law. Admission hearing is a one-on-one between the consumer and the judge. If the judge sees that this is not a consumer matter, he will dismiss on admission. And in these admission hearings, the opposite party is not in the picture yet. So suppose you file your case, but your admission hearing is taking long for whatever reason, like the court is busy with too much workload. Now a provision is there that if you file your case and if your matter is not admitted within 21 days, your case is deemed to be admitted and the matter will move forward. So many cases were pending because and they were stuck on this admission matter. Courts are busy, especially during coronavirus. So now 21 days there is deemed admission and your matter will move forward and you can send notice or summons to the opposite party. When you send a notice of the consumer court case to the opposite party, they have a maximum of 45 days to file their reply. If the opposite party does not file their reply within 45 days, the matter will move forward ex parte, without the party, without his reply. So there is a lot of pressure on the opposite party to take the consumer court litigation seriously. If your complaint, if your consumer court case is about goods which require testing, for example, the poison food case, the court can send the goods to the appropriate laboratory for testing. And the lab has to send its report within 45 days if possible, that what is the result. If any party disputes the government lab findings, they can approach a private lab at their own cost and they can file their objections that they can tell the consumer court that, my lord, for so and so reasons, the report of the government lab is not entirely trustworthy. They can take objections and they can file the private lab report to establish the true and correct facts. Now, talking about true and correct facts of the case, the consumer code, just like the CCPA, it has the power to call upon an electronic service provider to give any kind of information or data, any kind of electronic data. So, for example, any website deletes your comment. You as a consumer have commented something, the website deletes your comment. The court can call the website owner, whether you are the owner or whether a third party is the owner of the website. Consumer court can call these websites. It can ask, did this person delete this comment? It can ask that whether so and so advertisement or so and so layout or web page, whether it was shown. It can call for electronic data records that when I made my payment through your portal, whether the money actually went through or not. Sometimes in transaction errors, it can call for electronic data from the electronic service provider. Any kind of electronic data, consumer courts can call the parties. It can ask them yes or no questions. You tell me yes or no whether this was done or it was not done. It can even order cyber forensics of whoever is the server owner. All consumer courts can direct any person to produce not only this electronic data, but anything, any article, goods, data, record, register, item, any item under the sun. The courts also have a power of search and seizure, and when it seizes, the consumer court has the option: do I keep it? Do I let it be confiscated, or do I return it to the party? So search and seizure power, confiscation power is there with the consumer court, including the power not to return it. Court can keep it, confiscate it for the purpose of evidence. Just like the CCPA, the consumer courts can also do online complaint. You can do an online complaint on the consumer court. And in fact, the consumer courts go one step ahead. They say you do full video conferencing of your whole hearing, your whole case will be online. Just like the CCPA, the consumer courts can engage experts to assist it with the technical matters. So now the consumer authorities cannot be fooled by any tomfoolery, any technical jargon, any technical tomfoolery. Courts have the power to educate itself through the experts. Just like the CCPA, courts have strong powers to ensure execution of its orders. Order is passed, parties are not complying, you can file execution proceedings. And these powers or execution, they are so strong that if the party does not comply, the execution punishment can be imprisonment between 1 month and 3 years. So compulsory 1 month imprisonment and fine between 25,000 to 1 lakh. Compulsory 25,000 fine is there. So if the opposite party or if any party refuses to comply with the orders of the consumer court, there are strong steps which can be taken to secure the implementation and enforcement and execution of the order. Now, to elaborate on this execution a little more, there is civil execution and there is criminal execution. If a party has to pay me some money under the order, if order is passed, you refund 1 lakh or 10 lakh rupees to the consumer and the opposite party is not complying, I will file civil execution and I will tell the court in civil execution, you attach his properties. Attach means you do auction sale, whatever money is generated from the auction sale of the opposite party property, that proceeds from that will come to paying your debt. So this is civil execution, that if you are a judgment debt, if the opposite party is a judgment debtor, if you are entitled to money under the order and it is not complied, properties will be attached to ensure that the proceeds of sale come to pay your debt. In another kind of civil execution, the court passes an order to execute some kind of agreement. For example, you execute the cancellation deed of the house, or you do a conveyance deed for the society premises, and the builder does not comply. Civil execution proceedings I will file. I will tell the court, my lord, he is not doing the agreement. I will provide a draft of the agreement. Court will examine and scrutinize it. Court will execute the agreement on behalf of the builder with you for whatever are the legal formality. So that was civil execution, and criminal execution is for imprisonment and fine. So this is execution of the consumer court orders. Product liability is a new concept introduced under the Consumer Protection Act 2019. Product liability means a complaint has been filed by someone in the consumer court because some kind of injury or harm has been caused by the product. When harm or injury is caused by a product or by any service related to a product, you can do product liability action. This product liability action can be brought against three kinds of people: the manufacturer, the seller, and the service provider of the product. The Act sets out various scenarios when these persons are liable and when these persons are not liable. That is, there are certain defenses they can take. Chapter 6 of the Act has a long list, but one important provision is that if the manufacturer is untraceable or beyond Indian law jurisdiction, the seller will be made liable on behalf of the manufacturer if the manufacturer is untraceable. If harm or injury is caused by the good and manufacturer is not traceable, then the seller will be made liable to the penalty. So this product liability action is very, very important. If any goods cause you any injury or harm, you can take action, and there are certain types of defenses. Another defense, let me give you an example. If the product has such a nature that is so obvious, for example, the flammability of say firecrackers, and if injury is caused to you where you as a consumer are negligent around the firecracker and you do some fire mischief, then the firecracker seller or manufacturer, he is not responsible. Why? Because the nature of the product is such that it is obvious, it is inherent that you are supposed to take so and so type of care. Another type of example, if the product, if there is a disclaimer on the product that use this only under some kind of expert supervision or guidance, for example, prescription medicines, and if the consumer self-medicates, then the seller manufacturer are not responsible. It has deployed a warning that these are only prescription medicines. Consult your doctor, take only upon prescription. So there are various defenses which the businesses can take. Another example is that if they have given you a manual and you are supposed to follow and read the manual before using the product, that is one kind of defense. So in another example I can give you is that if they have told you to take certain kinds of precautions, but you have changed the nature of the product, you have done some tinkering, some different thing you have done to the product, you have changed the nature of the product. So for example, you purchase a car, but you go and you do your own set of modifications to the car, you add this and that to the car. So the manufacturer did not intend to sell the car that way. So if the consumer does some kind of change in the product and some harm is caused, then the manufacturer and seller are not responsible. So in short, product liability action means a harm or injury has happened and I am filing a case for compensation in the consumer courts. That is product liability action. Talking about how long a consumer court case is supposed to take. If laboratory is not involved, court case has to be done within maximum 3 months. and maximum 5 months if laboratory is involved, if some kind of testing is required. Appeals have to be done within 90 days. So these fast track provisions are there. Maximum 45 days reply for the opposite party is there. All provisions have been made to deal with disputes as fast as possible. During any of these proceedings in the consumer court, you can settle the dispute through mediation. Mediation is the process by which the mediator mediates the consumer dispute, and the mediator has to be impartial and independent. Consumer courts can refer matters to mediation only if the parties consent to it. However, certain types of matters cannot be referred for mediation. For example, medical negligence cannot be mediated if there is grievous injury or death, and matters involving fraud or coercion cannot be mediated, which is common in property disputes. There is also provision some part of the dispute may be settled, and whatever is not being settled, you continue fighting it in the consumer court. Whatever is being settled by mediation, you settle that much portion. 3 out of 10 things are settled. You settle that much. Remaining 7 out of 10 things, you fight it out in the consumer court. There are also some important things to remember about mediation. Any matter that has been mediated, you have done mediation, you have signed consent terms. Successfully, if it has been mediated, you cannot appeal that matter. Perhaps the most important thing to remember about mediation is that when mediation is still ongoing, the parties shall not initiate any judicial or arbitral proceeding in respect of that matter. So don't do another court case for matters which you are mediating. And another important thing to remember about mediation, if the settlement is arrived at and if a party dies, then obligation does not die. The legal heirs can enforce the settlement. The legal heirs of the deceased can enforce the settlement. But in scenarios, for example, where the settlement was to perform a surgery, but the patient has passed away, so the right to claim also goes away in such circumstances. If the obligation dies with the party, then the claim becomes impossible and the claim will not be carried out. Now, friends, whatever we saw about the consumer court was in the consumer court when the dispute has started, when the fight began. But the provisions of e-commerce under the new act, they apply even before there is any kind of dispute. The consumer e-commerce rules provide that an e-commerce entity can be either a marketplace e-commerce or an inventory e-commerce. The difference is very simple. Suppose I am Nike shoes. If I sell on Amazon website, Amazon is the marketplace e-seller. And if I sell on my own Nike website, then the Nike website is the inventory e-commerce. Even if you are neither inventory nor marketplace, you will still come as an e-commerce entity simply. The e-commerce rules are so brilliantly drafted that when we talk about e-commerce platform, websites are included, apps are included, even messages on your mobile phone are counted as e-commerce platforms. All these entities, the marketplace e-commerce, inventory e-commerce, they have to make certain disclosures. They have certain duties. The shortest way for me to explain to you what are their disclosures and duties is I can say that if you think you are entitled to it, 99% chance, yes, you will be entitled to it. For example, there are non-judicial agencies of the government, the National Consumer Helpline of the Consumer Ministry. Now it is through the e-commerce rules, it is made compulsory that if anyone raises a grievance on that National Consumer Helpline, the business will have to look into it. This is what the e-commerce rules say. You are now under obligation. E-commerce rules say that these e-commerce entities, they have to establish a grievance redressal portal and mechanism. What is this mechanism? They have to acknowledge your customer care complaint within 48 hours and they have to resolve it within 1 month. You have a customer care grievance, you lodge a customer care complaint, within 48 hours they are supposed to tell you complaint received, and within 1 month they are supposed to resolve it to your satisfaction. 1 month maximum is there. This is what the e-commerce rules say. Now the rules also say that these e-commerce entities have to disclose in a clear and accessible manner what is the legal name. Nike Shoes Private Limited, what is the legal name? What is the address of your headquarters? What are all your branches? What is the exact direct number of your customer care grievance officer? We saw in the CCPA action taken that the country of origin and other disclosures were not complied with and investigation is started. So these are under the e-commerce rules. If the goods are imported, they have to mention the name of the importer, the country of origin. They have to mention and comply all other relevant compulsory formalities. For example, the Food Safety Authority, if the FSSAI is involved in anything, you order chips or anything online, those disclosures have to be made. What is your FSSAI license number? We saw in the consumer court example that gold was sold online on Amazon. You have to provide the gold authenticity certificates. So these compliances are now made compulsory under the e-commerce rules. One more thing under e-commerce are arbitrary cancellation charges. Now the e-commerce rules say that you can impose a cancellation charge only if that e-commerce entity is actually incurring that charge from somewhere. It cannot arbitrarily levy a cancellation charge. And if there is any cancellation charge, it has to disclose that to you in advance when you are browsing the product or when you are doing add to cart, you are seeing your cart, it has to show you the cancellation charges if the cancellation charges are applicable. Next, if there are any certain tick boxes or check boxes, e-commerce rules say they shall not be pre-tick mark. That if there are 10 check boxes, consumer has to tick mark any of them, no pre-tick mark check boxes. Next, if the consumer has any request for refunds, the refund has to be processed as per RBI guidelines or any other prevailing and existing guidelines. You cannot have a policy that we don't do refunds, we have no refunds. If there is a clear-cut defect in the good or service, you have rights to get a refund. Many times these e-commerce entities, they have the star rating system, 1 star, 5 star. If there are parameters, the entity has to disclose what are the parameters for levying the 3 star, 5 star. So what they generally do, which is the correct thing, is that they show that this is the average of our customer ratings. So they cannot do any wrong thing like rated 5 star and they cannot show 5 stars. They have to show the basis. What is the parameter for levying this 1 star or 5 star? Refund of goods is made compulsory if there is a defect, and it says do not misrepresent your goods if there is fault advertising. The e-commerce rules say do not write fake reviews for yourself, and we have seen how CCPA has ordered inquiry and investigation. One important thing this e-commerce rules say, do not manipulate the prices for unreasonable profit. Two example. Number one, there are these sales events on the e-commerce websites. So the CCPA is doing investigation into price dip, that they lower the prices so much that it harms the competition. If any such brutal tactics, price dip tactics of manipulation of prices are done, then the CCPA can look into it. E-commerce rules expressly forbid it. Another example, is your taxi apps. They have surge pricing. Sometimes it is a peak hour, sometimes it is a holiday. The prices go up astronomically. Now the e-commerce rules say you do not do such kind of surge pricing. Another example is that during these sale seasons on the e-commerce websites, they will hike up the principal price and then they will say that we are offering discount 400 rupees, 800 they will show as the display price, and then they will say we are doing 50% discount. Not allowed. E-commerce rules expressly prohibit. Now, one more important e-commerce provision talking about those e-commerce marketplace entities and the vendors who come and who sell their products. When these vendors approach Amazon, the vendors have to make all the disclosures to Amazon. What is my legal name? What is my headquarter address? What are my branch offices? Who are the relevant people in the company? The directors, the customer care officer. So if the vendor has done something wrong, the consumer and the consumer agencies want to catch the vendor, but if the vendor is untraceable or he's escaping the law, the consumer authorities can approach Amazon that the disclosures what he had given you or what you were supposed to take, you give us the disclosures so we can catch the vendor. In short, when it comes to e-commerce, if you think a consumer deserves this, chances are you are right. Yes, consumer gets it 99% of the times. Express provision is made in that regard. So there are two websites that I want to navigate you through. One is the Confonet, which I told you gives you the details regarding your consumer court case. Go to Google, type Confonet. Sometimes this Confonet website can be a little slow. In Confonet, these three things are the most important: cause list, judgment, and case status. Let us start with cause list. Cause list for non-lawyers, cause list is also called daily board. Now, suppose in non-lawyers and for non-lawyers, I will explain. Suppose your consumer court matter is going on, and suppose the court says that आपकी अगली तारीख, the next date is given to you on, say, what is Monday? Let's take Monday's date. 26th of April is Monday's date. Now, you will be wondering what is the serial number at, what is the courtroom number. That is what you will get from cause list. Let us look at Monday's cause list in some of the courts. I said this is all in public domain. So let us look at 26th April cause list for additional DCF for Mumbai Suburban. You fill in the parameters. There is the date aspect. What date daily board you want to see? You select the court name. So when you select the state, it will show you all the different states, and the first it shows you is the National Commission. If you do National Commission and search, it will show you the daily board of the National Commission, and all the matters, you can see that the matters are given. The details of the matters are given, that on that particular date, what are the matters scheduled for that day in that court. If it is a state commission, you click your state, automatically automatically state commission will be selected. You do search, click all, and it will show you that for Monday, what are the matters scheduled. So for Monday in Maharashtra State Commission, there are 28 matters scheduled in DB1. There for bench number 2, there are approximately 42 matters, and there are various other matters. So this tells you that what serial number your matter will come at. This is cause list. Now you will notice, my friends, in cause list, it gives you the case. It gives you the code of your case. So I will show you now how to use that code, and that brings us to case status tab. When you come to case status, you can see the details of the history of your court case. Select the court. Now we have selected Maharashtra This is state commission. State commission, in case status, select which state you want. You fill in the code. We saw that the code you can get from the cause list. You fill in the code and click the search button. When the thing disappears, it is good news. If it was a wrong code, instantly it would tell you no results found. When everything disappears, it means it is just processing and loading. So here we filled the code and we clicked the search button and we saw what are the details. This is the gentleman who has filed the case, and this is the gentleman against whom it is filed against. You come down, view history and orders. It is self-explanatory. You can see the history and orders. So now, in this gentleman's case, so many dates have taken place. And if you want to see what has happened in the hearings, you click this daily order or proceedings. In 2012, so and so was happened. So and so things took place. So when you do view history and orders, you can see all the things that took place in your case. Matter stands adjourned to so and so. So that is the next date given, and whatever is the judgment that will get and see. So now we saw that judgment, and we can see what judgment has been passed. In this order clause, complaint is allowed with so and so cost. Opponent builder is directed to execute and register agreement in respect of the flat. So this is the relief. 1 lakh compensation is given. So this is the relief which has been granted to the complainant. This all we can see from the case status tab. Now, third and foremost, judgments tab. Judgment as a self-explanatory, you can obtain judgments. You see the search by, these are various parameters by which you can search the judgment. Actually, let me take one step back. Coming back to the case status. Sorry, I will take one step back. We saw that if we have the code number, you can search your case. But many times you are trying to look for a case, you do not have the code. You see this right side of the counterpart, you can use these parameters to search for your case. So let us try searching this case using the right side parameters. It was filed in the year 2012. So from date to date, we put of the year 2012. And we have various parameters. You can choose to fill any one of these, or you can choose to fill multiple one of these to try and get your case status. So let us fill one. I fill the date and I fill the complainant. This fellow's name is Gulke Achra. So give a very nominal search. Don't try to be too specific. Try to give as minimum as possible. We have filled the parameters, and here it gives you the option, all of the above or either. So I have the complainant name, but I want to be sure. So I want to fill in more details. I have filled in the consumer name. Let me try filling the respondent name also. I doing just one. Either of the above means it will show you results for all the parameters. It will look at these parameters individually. And all of the above, when you click, it will look for all these parameters in the court case. All of the above, even if one of the parameters doesn't match, it will not show you that in the search result. So let us try giving the search. I have filled the complainant name, I have filled respondent name, and I want to say either of the above. Show me a search result where there are either. I have clicked the search button and it has shown me that there is the so and so are the complaints which are filed. And when you get this search result, you can get your code, the code case from here. So this was case status. Talking about judgment, it just like case status search, even judgment has various parameters. The simplest one of them is between dates. So I want to see that from 1st January 2021 to 24th April 2021 today, what are the judgments passed by the National Commission? You do this between dates tab, you put the start date and date, and you give a search. It will show you what are the judgments which have been passed by the respective and relevant courts. So we have seen that in the National Commission, so and so judgments have been passed from till today in this year. Approximately 10 to 20 pages worth of judgments have been passed. So this brings me to the end of Confonet. Before wrapping up Confonet, I will remind you the three important types are cause list or daily board, with which you can see the daily board of the matter, what number your matter is at, and what is the code. We have seen case status. You fill the parameters and you see all the history of your case, and you see judgment, that if you want to download any judgment. Now let's come to the e-Dakhil website. E-Dakhil website is for filing your consumer court case online. Do enter website. Like I had said, they have video tutorial and PDF tutorial. They have given it in English as well as in Hindi. You can see the videos. They have given for registration, for filing everything, for filing consumer complaint, for filing appeal, all the types of things that you can file. They have given you a guide, and all the types of things you can file through this website. When you open this website, the first thing you have to do is register. When you click the registration tab, it will show you where all in India, which all consumer courts in India you can use this website for. So you can see the various states, and they have the corresponding Andaman and Nicobar State Commission, including district. Some states do not have this e-Dakhil website. For example, you can see Tamil Nadu, Kerala, they do not have that yet. Sometimes it so happens that the states have their own e-filing websites. Now coming to the registration, you fill your parameters, you fill your email ID, you fill your password, you fill your address, etc. You will be required to put your ID proof. Choose any one of the following ID proof: voter ID, PAN card, passport, ration, BPI card, driving license. Just fill in the number, whatever is the serial number of whatever respective ID proof. You click choose and you upload. One important thing, let me point out over here. Here they tell you to input your name, but below that they tell you to input your father's name. Now, if you input your father's surname, there is one small error that in father's name, if you put surname, it will not get registered. It will give you an error. So when it comes to father's name, just put your father's first name and you will be able to register. After you register, you will get email as well as SMS OTP. You have to do the needful. Then you can log in. You log in. When you log in, it will show you this screen. And here are the two important tabs: filing and reply. Filing, if you want to file a new consumer court case, you come under here and you click file a new case. Read the disclaimer and click accept. It will ask you whether you want to file a consumer court case, or you want to file a revision petition, or you want to file an appeal. Let us see filing a consumer court case. We saw that under a consumer law, it is only the consideration that is paid that is relevant. So this portal, when you want to file a case, it will ask you how much amount you have paid. Friends, when you input the amount, automatically it will determine which consumer court it will go to. You don't have to make that mental calculation. Platform will do it for you. It will show you in the next step which consumer court it goes to. And here is the court fee slabs. So whatever is your value, these are the slabs. Up to rupees 5 lakh if you have paid, 0 rupees court fee. And then these are the slabs: 5 lakh to 10 lakhs, 10 lakh to 20, 20 to 50, 50 to 1 crore for district consumer court. For state commission, these are the respective slabs. So whatever is the amount you're entering here, this is the corresponding court fee that you have to pay. You fill the amount and you fill place of cause of action. where the cause of action has arisen. Maharashtra, MSD. Click continue. Now I told you that it will automatically determine which code. You come to the pre-details, it will tell you case filed in DCF, District Consumer Code, because it is 5,000 rupees. Now let me show you the example of a higher amount. Now let us input the maximum value. So my presuming that I have paid 9,99,999 crores, exaggerated, but for example, even if you put your local over here, it will still give you national commission in the designated code. So this website does the calculation for you, which code it will go to. You have to be careful about where cause of action arose. When you click that next, you fill in all the details. There is these are the complainant details and these are opposite party details. Suppose you have your own advocate, you fill in your advocate details. You fill in these things and you click save draft and click on next tab. You will notice that some of these are red stars. Those are compulsory fields. Now you will ask me, what if we are more than one complainants? Or similarly, what if we are filing against more than one person? There are these tabs here, additional complainant and additional opposite party. You fill in the details and you click add. So you can add, there will be complainant number 1, complainant number 2, opposite party number 1, opposite party number 2, how many ever you want. The last stages of this, one of the last stages, you upload the various parts of your complaint. There is the index, you click the file and you upload. There is the list of dates and events. What are the sequence of events? You choose and upload. Memo of parties, who is the complainant number 1, 2, 3, 4, what is his address and identity? Who are the opposite parties number 1, 2, 3, 4, what are their address and identity? Full and final, your complaint with the affidavit. Now friends, this portal is so interface friendly. Sometimes you have to upload more documents in the course of argument, in the course of your hearing. You have to file applications. Sometimes there is an application for condonation of delay. Sometimes there is an application to implead a party. Sometimes there is an application for interim relief. You click here, add document. You can define what is the document that you are uploading. You upload the PDF of that. So this tab will help you upload all your documents. You click upload, upload, upload. The last step is you click finalize and submit application. Here there is a preview button. Whatever you have uploaded and filled, it will show you a preview. These documents are there and these parties are there. You click preview and it will show you that your cases is filing in which court. This is a formality. Have you registered on the National Consumer Helpline? You click no, it is okay, but these tick boxes are all compulsory. Do not blindly click them. Please read them. That please confirm that the following have been cross-checked. You have verified and gone through your complainant details, your opposite party details, your additional complainant, additional opposite party, all chronological sequence of events, all the documents are proper. And if you have seen the preview, please pay attention to this red, bold and capital. Once you finalize your case, you cannot edit it. You click finalize, it will take you to the payment portal. And with that, you can file your case and your case will be filed online. You will get the details on SMS and email.
Is it mandatory to send a legal notice to the other party before filing complaint at District Commission under CPA Act?
No, statutory notice is not compulsory, but why it is advisable, you be sure that there is actually some kind of non-compliance. It should not be the case that you go to the court and the party takes the stand. I was so willing to give. Why did you not ask? So we send notice to establish non-compliance. We send notice to establish that we have a grievance, and not even a notice. You don't even need to send legal notice. You send an email saying that please give me refund or replace my product. You send email, you send one simple letter. It does not have to be legal, does not have to be advocate. You just show any normal correspondence. SMS also is okay. Show some normal correspondence which shows that you have some grievance, there is some disagreement, there is some non-compliance. I repeat, it should not be the case that you go to the court and they tell the court that I was so ready to give, he never asked. And if that is the case, court will levy cost upon you. So be careful about that. That is the answer to that.
How do you file a complaint against online travel portal for unfair deduction of refund for unused international air tickets?
Unfair contract, the new Consumer Court Act, it gives you this option of unfair contract. That is one thing you have. And it says that cancellation charges are supposed to be disclosed and declared online. So that is another offense which the company has done. And there are the wide unfair trade practice, restrictive trade practice, and deficiency in service. So unfair contract, e-commerce violation, deficiency in service, unfair and restrictive. These 5 offenses you can file. These are the 5 types of cases. Mention all these as offenses in your complaint and you can file it online.
Can a consumer file a complaint under the definition of defect and deficiency of services in the
Yes.
same complaint, or it has to
See,
be filed separately?
defect is for goods, deficiency is for services. If there is something, for example, you call for something from Amazon, there is goods as well as service. So if you can show a defect in, so even if your goods are not proper, it is deficiency in service. So the only main ingredient is that you should be given a good as well as a service. So that you have to keep it. If he has not provided you with goods, so talking about builders, when builders sell flats to you, it is not goods, it is only service. So goods cannot come under builders, flats, and services.
Is Consumer Protection Act applicable to a right to information applicant wherein public information officer has not replied to the RTI applicant? If
There
yes,
are
where does
contradictory, unfortunately, there are contradictory judgments in that regard. Some courts say that yes, you are allowed to come. Other courts say, other district and state commissions say you are not allowed. There is a discrepancy, but it's okay. You can file, you will most likely succeed.
okay.
In fact, just make a proper, that is where the art of advocacy comes. Make a proper representation, surely they will accept. They cannot deny relief on the ground that there is another remedy. Consumer court is an additional remedy. Closing remarks are that as far as consumers are concerned, consumer is now not just the king, but he's a Maharaj, because the rights are so strengthened now. So that is the closing remarks for consumers and customers. As regards law students and lawyers and practicing lawyers, consumer can be a good field. Find out the high profile sectors for practice. Insurance is a feasible field. Travel, airlines, real estate, insurance, medical. These are all very sustainable fields for law students and lawyers to set up practice in. Consumer courts are natural justice, speedy remedy, and rest assured, I have seen consumer judges go out of their way to give relief to the consumer who have been aggrieved.